We're now up to Chapter 7, and this is just the legal system, which I think most of us are pretty familiar with from TV crop shows. So, a jury is the people that render a verdict, the plaintiff is the person who is complaining about something, and the defendant is the person who defends themselves. So this comes from common law in the United Kingdom, which was just tradition. And so precedent is previous court decisions that establish a pattern, and similar cases in the future are judged by comparing them to previous verdicts, which is very common, especially in cybercrime issues where the law is often not clear. So civil law is where you have lawsuits, and it's usually about money, as opposed to criminal law. Constitutional and federal law. There's the federal law, there's the statutory law, which can be also at a state level, and there's regulatory law, which is the stuff that the current MAGA Republicans disapprove of and call the deep state, where an agency like the IRS or the FAA just makes a regulation, and they don't have to go through Congress and get it. They make rules. That's regulatory law, of which is a big issue in security as you try to achieve compliance with all these rules. So the court system, there's all kinds of specialized courts at the bottom, and then there are appeals courts where you complain about things, and ultimately you can appeal things up to the Supreme Court, as we've all seen a lot of cases go. So, all right. And there is nothing higher than the Supreme Court. And there's 13 appellate courts and so on all over the place. And I don't think you need to know all these details for this. Even for a CISSP, you don't go that much in detail. But there's different kinds of trial courts, like probate and family, small claims for small matters, and municipal ones. But the stuff more relevant to us will come down a bit later. Okay, in the courtroom, this is something an expert witness would have to deal with. You have jury selection and then testimony of witnesses, and your expert witness is one of those witnesses. So the jury is selected. Their questions are asked by the judge and the plaintiff and defendant attorneys to decide who they feel like is biased, and eventually that's the process called voir dire, which stands for something or other in Latin. I think it might be to see to say, I'm not sure. But anyway, where you talk to people to decide whether they appear to be biased. Sometimes you sequester the jury so they can't read news or talk to outsiders about the case. And you get contempt of court, punishes you if you violate the rules of court procedure, which can be very serious. One of the big issues is if you are a journalist and you have a confidential source, you are not allowed to refuse to divulge that confidential source. The only people who are allowed to do that are married couples and priests. So if you refuse to divulge your source, they can throw you in jail for contempt of court, and a lot of journalists do go to jail for long periods of time in order to protect their sources. So the opening statements summarize what they're going to do. The defendant does not need to defend themselves or speak because they're presumed innocent. The prosecution has to prove they're guilty. So you have direct examination of witnesses and cross-examination going back and forth there. The jury deliberates, and if they can agree on the answer, then they have a verdict. Otherwise, they have a hung jury where they cannot come to a decision. And now you have to either give up or have a retrial. So criminal charges are prosecuted by the government even if there is no one to complain. For example, if somebody gets murdered and there's no relative complaining or anything, you still prosecute them because that's considered a serious crime. But civil trials are just arguing over amounts of money, and if nobody is complaining, nobody's pressing charges, nothing happens. Somebody has to go to court and file a lawsuit. A deposition is witness testimony not presented in court, but just recorded by an attorney and presented as a recording. All right, that's the game. Civil trials have depositions, criminal trials don't, and so on. All right, so then we get down to stuff that's really more relevant to us, like the constitutional protections. The First Amendment gives you the right to speak and also the right to keep silent, which has been turned out to be very important. Originally, it was not interpreted as giving you the right to keep silent. The only issue was you had the right to speak, but it was interpreted, I think, in the 60s to give you the right to keep silent so people could refuse to recite the Pledge of Allegiance in class if they didn't want to. And after that, Apple used that defense to protect themselves, and the FBI came to them and demanded that they write a hacking tool to hack into an iPhone so they could get evidence from it. And Apple defended themselves on the grounds that that was forced speech, and they are not required to speak on the grounds that computer code is speech. And that might have worked and it might not have worked. The FBI dropped the case because they were able to buy a hacking tool from Celebrite, which got onto the phone. So it wasn't celebrated. Some people said it was. Some people.
I already told you, it's out there.
Who was it?
Company out in Australia.
An Australian company. Okay. Yeah, I did not remember that.
The guy, the former employee, David Wang, he was the one that kept hacking Apple and Apple suing him.
If you got an article about that, please send it to me so I can add it to news. I can't remember this. Anyway, they got some hacking tool somewhere and they were not able to continue with the case because they had to claim this was the only way in. And when they had another way in, the case stopped. Now, the Fourth Amendment is even more directly relevant. The Fourth Amendment means that the government cannot search for evidence without probable cause and a search warrant. And this really matters because if right now the police use stingrays all the time, and a stingray is a cell phone, a fake cell phone tower they mount in a truck and park in your neighborhood, and it now intercepts all the cell phone calls for blocks around, including the ones that are not from people they're authorized to surveil. And the same thing's true of much collection of email and so on. They get a lot of data from people who are not in fact the target, and then they promise not to look at it, and there's arguments over whether they do look at it. So there's even the very strange process of reconstruction, parallel reconstruction. The NSA spies on people, and they're only allowed to spy on foreigners, but they collect data from American citizens also, and then they hand it over to the FBI that uses it in court to prosecute people, but they cannot admit that it was illegally obtained in court, so they engage in something called parallel reconstruction. They make up a fictional story saying they got that from an informant that doesn't exist or something, and that's what they tell the jury. This is a very strange process, but it is happening and apparently legal, although it sounds like it ought to be illegal. So this is the exclusionary rule, says you can't use evidence that was seized illegally. And there's fruit of the poisonous tree, that if you originally did something illegal to obtain evidence and that led you to more evidence, all that evidence is inadmissible. All right. And there's a motion in limine, which is what a lawyer requests when a lawyer requests to exclude evidence for a trial on the grounds that it is somehow prejudicial or illegally obtained. So search warrants, I say the most important thing for forensic investigators, you need to get a search warrant in order to seize evidence, and the search warrant will specify what evidence you're allowed to seize. So I mentioned before, when you're investigating Windows images, the first thing you do is go to USB Store and get a list of all the USB devices that have been attached to this Windows machine, because you probably need to get another search warrant authorizing you to seize those things, because those are related sources of evidence, and they weren't covered by the original search warrant. And you have to demonstrate probable cause and get a judge to sign off on it, that there's reasonable likelihood that these pieces of evidence you're seizing will contain evidence of a crime. All right, and so it is actually very complicated. One of the really big complicated issues is when Microsoft started hacking into botnet servers and shutting them down, and even sending out stuff to automatically fix vulnerabilities in machines to free them from the botnet. This involves taking action on machines that you do not know where they are, you don't know what state they're in, you don't even know what country you're in, so how can any judge possibly have the authority to authorize that? And yet it has happened several times. Then there's warrantless searches. Under the Patriot Act, the law enforcement has great powers in a case of terrorism or suspected terrorism to just pretty much ignore all these laws and seize stuff. And also when it's an emergency. There's exigent circumstances and you can ignore all these rules and seize evidence. All right. Also, of course, the person can consent to let you search their stuff. And then, of course, there's no issue. That they don't need a warrant for that either. There's the plain view doctrine that says if you can just clearly see something without going into private property, then it's not considered private and you don't need a warrant to see it. All right. A plain error is a mistake made in the court proceedings. There are rules of the procedure. And standing is a huge issue. This is the big issue in attempts to stop Biden's student loan relief. Somebody has to go to court, and standing means you are being injured by this, and you can now complain. And they had great difficulty finding anybody that could claim they were injured by Biden's student loan relief. That was an issue there. All right. There's a lot of cases on it. So anyway, I mentioned the Stingray, this device that intercepts phone calls. There's another device called a pen register that just records all the phone numbers people are going to. This is essentially what the phone company has to give you a long-distance phone bill, back when they used to do that, before everybody just gave you a flat rate. And with the right court order, they can seize that. So they can get a list of all the numbers that were called and when. They do not get the contents of the calls, the voice, but they know who called who. which is often all you need. All right. So then there's GPS tracking. Now we have GPS all over the place, and the GPS unit in your car records everything. You can get data off it to see where you've been going, and they can also attach a device to your car which tracks you, and they can often do that without a warrant. Law enforcement agencies have claimed that they could have just had a car following you around, and this is just a cheaper way of doing the same thing. And that's, as far as I hear, being battled in court. I'm not sure anybody exactly knows how legal that is. All right. But here's the argument. A person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements. So that would be one side of it. And also the undercarriage of the car is part of the exterior and therefore not afforded a reasonable expectation of privacy. Those are some of the basis by which the police do that. All right, then there's traffic stops. You can't search a cell phone of someone who's arrested without a warrant, which is a big deal. And then there's the Fifth Amendment, which protects you from self-incrimination, so you can just say, I plead the Fifth Amendment and I'm not going to answer any questions, which is, of course, a big deal. We've all seen that. And then there's the Miranda warning, which recently just got weakened. They're required to warn you of your rights when arresting you. That was just weakened recently by the Supreme Court. All right, and then the Sixth Amendment is not particularly relevant. And then there's the Federal Wiretap Act. These are the crimes people are often breaking. The Wiretap Act says you cannot wiretap telephone or electronic communications. You're intruding on them, and it's really quite ruthless. This is why you can get a $30 software-defined radio, plug it in your computer through USB port, and you can now receive and send cell phone signals. You can learn how to do it. There's plenty of techniques. The problem is it is fantastically illegal. All you need is an ordinary computer and a $30 device and open source tools. But if you do, you're violating the wiretap law, which is really ruthless. The laws protecting telephone communications are quite strong. Then there's the Foreign Intelligence Surveillance Act, which means, of course, that you can spy on anything foreigners are doing in America, which is a huge financial problem for America. European companies want to use American services like Amazon Web Services, Google, Yahoo Email, and so on, but they can't. They have no rights over here to privacy, so it violates European privacy law for European companies to use American services. And there's a whole series of temporary stopgap legal frameworks made to give them temporary rights to do that, because the financial need to do that is so large that they make exceptions basically to their privacy laws for it. And the Computer Fraud and Abuse Act is the act by which hackers are prosecuted. It's the one most penetration testers and security researchers are most afraid of. This law was written a long time ago, before there was much of an internet, and it therefore defines computers that are important. It covers computers that are used in interstate communication or commerce, thinking that that would only be a small number of servers. But the problem is that's almost every computer now, every web server and everything. So it ends up protecting, in principle, almost every computer. And this leads to the strange current situation where a company that protects their network with all these legal things that are full force becomes less secure, because there's a whole bunch of white hat hackers out there that would like to test your security and tell you about it. And if you want to make your company most safe, what is generally considered wisest now is to have a vulnerability disclosure policy that says we will not prosecute you, even if you break the law, by testing our security and finding our flaws, as long as you tell us. We won't prosecute you, and we'll even give you like a reward or something, or the bug bounty program. So this means the security experts are in the difficult position of trying to explain to management that we would be safer if you stopped using the law to protect us so much, which is a hard sell. But it's a lot easier now that the U.S. military has begun having bug bounty programs. The Department of Defense is, I think, now just starting their third bug bounty program, asking everybody in the world to hack into military DoD things so they can learn about it, which is the modern solution. Then there's CALEA, which means that telephone networks must have a way to wiretap phone calls, and they do it in response to a court order. And the FBI is constantly trying to get a internet version of CALEA, so they can demand to see internet traffic, but there is no corresponding law, so most ISPs do not have that. And the main argument against it is they said if we had that CALEA for the internet, then nobody could allow anybody to have an anonymous connection to a wireless network. Everybody would have to sign in, we'd have to take your ID and know who you are when you go in a coffee house, because we would have to have records in case the cops came and said who was using this machine at such a time. So they've succeeded in saying it would be too burdensome and foul up the internet so far. But the law enforcement agencies are constantly trying to get it. And right now they're passing one like that in Britain. And many companies are saying they're going to pull out of Britain as a consequence. So we'll see how that goes. And then, of course, the Patriot Act after 9/11 that created huge exceptions to almost all these privacy things for purposes of investigating terrorism. All right, and then the DMCA passed under Bill Clinton to make it possible to do financial transactions over the internet, defined a digital signature as equal to a pen signature to make a deal, and it also defined copyright infringement, so that you could sell copyrighted material over the internet and punish people for copyright infringement, which has led to this being usually the most powerful way to take anything down on the internet is to complain that it infringes copyright, because the rule is you can put up stuff like you can have a hosting service where your users just put up things you don't even know what they are, and you're not legally responsible for them as long as you take them down and request. So people will just take them down without examining the request, and so there's a whole industry of making bogus copyright claims that have no merit, because most of the time that will just take things off the internet if you want something taken down. All right, there's a Cloud Act that allows law enforcement to gather data from clouds domestically and internationally, but it hasn't been ratified by other countries, so I'm not quite sure how much good that'll do you yet. And then there's some tests to see if evidence is admissible. The Fry test shows that you're using science that's demonstrable and not experimental, and the Daubert test says you have to have benchmark testing on your tools to make sure they're operating to recommended specifications. And the federal rules of evidence deal with expert testimony. So scientific, technical, or other specialized knowledge will assist you, and a witness is qualified as an expert. An expert witness is the only person who is able to testify about their opinions and turn opinions into evidence. Everybody else is only allowed to say what they really saw or heard. Their experience is evidence, but their opinions don't matter. But the expert witness can state opinions, and they count, because they're trusted to be an expert, and the weight of that is determined by how much you're convinced that they really are an expert. And this is the role forensic examiners have. So that's the game. You have to convince people that you're an expert so they trust you. All right, and you have to have a report that specifies the statement of your opinions and the exhibits. And we've talked about this before. List of other cases, a list of the money you're making, and so on, so everybody knows what your role is, and they can decide whether they trust you or not. And my instructors that are real expert witnesses in court, which I'm not, have shown to me it's pretty much a matter of having a good presence in court. Have a snappy answer, have good answers, and be more confident. You have to really understand your tools and be very clear in explaining them. And just like any other debate, if the other side is clumsy and doesn't know what they're saying, you expose that, and then they trust you. All right. And so there's federal rules of evidence that determine that there are records created in the normal course of business and are admissible, things like logs and other things automatically created by the machines, which is very important. Otherwise, that stuff would be hearsay. And there's a thing called best evidence we've talked about. If you want to go to court, you want to say, this is the hard drive taken from the machine that was used to commit the crime. You can't just say this is a copy of the hard drive. The hard drive itself is best evidence. This is the real object used in the crime. Some kind of copy of it is secondary evidence, which is not worthless, but it's less valuable than best evidence. All right. And so you have to have a defense counsel and so on. So that's why you take the original, you make a forensically valid copy of it, you give a copy to the defense and a copy to the prosecution, and their examiners can independently examine it. Nobody messes with the original. That's locked into a safe and presented at trial. You work with copies. Now, California passed a Consumer Privacy Act, one of the very few privacy acts for internet data in America, modeled after the European Privacy Act, which is very strong. And so this is only beginning to be enforced, but it enforces a lot of things, like people can demand to see all the data that a person is holding on the internet. They can demand to have data deleted, so which you cannot do in most of America and most services. Right, and so the European Union has a lot more privacy laws, very strong ones. The main one being this one, GDPR. And a couple new ones just came out this year, also requiring providers to disclose the algorithms they're using to select things like TikTok. And we'll see what comes of those. Those haven't been tested in court yet. But GDPR has led to a few fines. The problem is the fines can be too small. Although here they claim it can be 4% of the global annual turnover, so there may be some big GDPR fines coming out. So you have personal data, and it limits your data collection and retention. All right. And then China has the greatest restrictions on internet content, but I think it's mostly just the Great Firewall where they limit what their people can see. So they can't connect to most Western services in China.
The Great Firewall is a little backdoor for a company to go through.
Oh, it did? I didn't know. Okay.
So other company, like overseas company, they have to apply, and then China Telecom is put all the data line, do it without through the firewall to Hong Kong, and then the US company, the one that you use to going out to the internet for
Yeah. The ISP, yeah.
yeah, it's supposed to do all the blocking of all the unprohibited terms and then go out. The government don't.
So the external,
trust them.
so the external companies apply to the government and get permission to get through, and then the ISPs all know they're allowed to let that stuff through.
Yeah, the ISP is supposed to be good terms, guarantee or something. You provide some, guarantee that they will block all the prohibited terms and then they go out.
You know, we had the same thing in Utah. Utah, several years ago, passed a law that every ISP must block pornography unless they're explicitly asked not to, and that would be the default, but as far as I know, it never happened. Australia also promised about 8 years ago, the Prime Minister of Australia said he was going to block all malware and all crime, phishing, and all porn on the internet. And people told him there's nothing you can buy that will do that, and they tried for years and spent millions of dollars, they couldn't do that. But anyway, there's a lot of people.
Counter that do all the checking of the blocking of the terms and then get out without.
Who's that?
Cloudflare.
Cloudflare?
Cloudflare.
Oh, Cloudflare. Yeah, Cloudflare.
They're the one that blocking supposed to check all the forbidden terms in Hong Kong.
Oh, Cloudflare is what's blocking it in Hong Kong. That's interesting.
Yeah.
Okay.
So it's going through the firewall.
Oh, okay.
It has to be like on good terms.
Because Hong Kong is much more open than mainland China, I think.
They're supposed to be.
Yeah. Anyway, and then India has some laws which protect the privacy of their consumers and so on. I don't know much about it, but this is increasingly important to American businesses because American businesses are mostly moving their manufacturing out of China to India, like iPhones and everything else, because as relations get more and more hostile between the U.S. and China, U.S. companies are no longer willing to have their supply chain reliant on China. All right, so that's, let's take a look at a Kahoot, which is here.
The Australian company is Asana Securities.
Australian, oh, okay, what was it?
Asana.
Hasam?
ACIMUTH, Asana Securities in Australia.
Yeah, if you can send me a link about it, it would help me. I'll just make a note of it. Hasimus. Yeah. All right. I'm glad to know about it because there was huge argument of who it was. Some people said it was the company that hacked into the iPhone. A lot of people said it was Celebrite, and some people said it wasn't. Okay. L3 Intelligence. Okay, thank you. still trying to get in? Looks like you might need to use a different browser or something. Give it a little while, let him try and get in. Ah, that looks better. All right, good. All right, let's give it a try. All right, so what law is made by state legislatures? That's statutory law. All right, good. All right. When you ask jurors questions to see if they're biased, what's that? That's voir dire. Good. All right. All right. So what request does a lawyer make to suppress evidence? That's a motion in limine. That's what they call it. Again, Latin, and I don't know what it means. All right, which device records your phone numbers that you dial? It's a pen register. The Stingray intercepts the phone call so you can hear the voice, but this just records the phone numbers. All right. If a hacker intrudes onto a network, what law have they violated? It's usually the CFAA. That's the main one. That's what protects computers. The wiretap law would apply more for telephone conversations and transmissions. So the CFAA is the main one that hackers are prosecuted under. All right. I don't know who that is. Okay, that looks like a real name, Mercer. Okay, that's a real name. All right, good. All right. So stop this recording.